one dude's known.
What room is it?
It's the one on the other side upstairs.
All right.
I guess dude's known to always have a gun on him, so.
Oh, good.
What's up, Sarge?
Hey, what's up, man?
229, top right, David Turney, always got a weapon, and Mandy Burton, Amanda Perkins, or Trixie, and she's got warrants also.
She's advertising, huh?
Yeah. No blonde.
Okay, that's not who I thought it was. There's a girl around here that runs around with the name of Trixie. She's cute, so it's not her. That's what we need.
The great equalizer. You got your job, right? You going right here to the next stairwell. Nobody gets down.
We just want to stand back and let them handle business. In case they call for us to intervene, we don't kick doors in, we don't arrest, we don't do none of that. Okay?
Yeah, they already got the keys and all that already.
So even if they say, we need you to keep this door in, we don't do that.
They said that they're going to kick it in.
As the officers follow the bail bondsman, Sergeant Coburn instructs Officer Lambert not to kick in doors or arrest anyone, but to leave those tasks to the bail bondsman. In Arkansas, when a defendant is arrested and granted bail, a licensed bail bond company can post a shady bond to secure the defendant's release from custody. The bond is a financial guarantee that the defendant will appear for all required court dates. If the defendant fails to appear, the court may issue a bench warrant for the defendant's arrest and initiate proceedings to forfeit the bond amount. Under Section 16-84-114 of the Arkansas Code, the bondsman or their licensed agent has the legal right to arrest and surrender their bonded defendant without needing a new court warrant. This authority stems from the nature of the bail agreement itself, because by entering into a bail bond contract, the defendant effectively consents to certain intrusions that would otherwise be illegal. For instance, courts have long recognized that a bail bondsman may lawfully enter the defendant's private property, even forcibly and without a separate judicial warrant, to apprehend their client, because the defendant has contractually agreed as a condition of release to submit to such custody. As the Supreme Court explained in the 1872 case of Taylor v. Tainter, quote, "When bail is given, the principal is regarded as delivered to the custody of his sureties. Their dominion is a continuance of the original imprisonment. Whenever they choose to do so, they may seize him and deliver him up in their discharge. And if that cannot be done at once, they may imprison him until it can be done." The court continued, quote, "They may exercise their rights in person or by agent. They may pursue him into another state, may arrest him on the Sabbath, and if necessary, may break and enter his house for that purpose. The seizure is not made by virtue of due process. None is needed. It is likened to the rearrest by the sheriff of an escaping prisoner. This means that there are many situations where a bondsman would have the authority to arrest an individual when a police officer would not due to Fourth Amendment limitations, which do not apply to bail bondsmen as private citizens. And the officers here seem to be on the scene as backup if needed during the arrest, as Section 16-84-114 requires any bail bond agent attempting to apprehend a defendant to notify law enforcement. However, it is important to note that a bondsman's authority applies only to their own clients, because the contractual consent applies only to the bonded defendant. Accordingly, while the bondsman inarguably had the authority to arrest Mr. Turney as a client of city bail bonds, the evidence is unclear as to whether their arrest authority extended to Ms. Perkins, who they were also at the motel to apprehend, as her court records show no indication of any bond being posted. Instead of going to room 226, where Mr. Turney and Miss Perkins were staying, the bondsman and the officers make their way to room 229. According to a statement from the hotel employee who was working at the front desk, he provided a bail bondsman with a guest list that showed room 226 was registered to Miss Perkins, explicitly told him the individuals they were looking for were in room 226, and pointed to the room number multiple times on the list. Well, despite all this, the bail agent seemed to believe that the wanted individuals were in room 229 and gathered outside that door.
David! On the ground! On the ground! I will blow your the other side of this place. On the ground!
Baby, this is
Where's the guy?
Just stay right
It's my daughter's birthday, dude. Please, y'all.
Stay right there.
Please. It's okay, guys. It's
Just stay
okay,
right
baby.
there.
It's your birthday. I'm so sorry, baby. Y'all, I'm so sorry. You hear me, baby?
What'd I do?
Bugaloo.
Come up here and she was upset.
I'm so sorry. You hear me? It's okay, baby. Y'all, we're okay. Guys, we are okay.
Man, I tell when he...
Bubby,
Let me see his tattoo.
hold me. I don't know, baby. Hold me. Hold me. I love y'all so much. Do you know how much I love you? Hey, look at me. Look at me. Do you know how much I love you? You do, don't you?
You want to sit somewhere outside?
I love you so much.
Y'all want to come outside?
Hey, can I get them jackets and stuff, please?
Just step out right quick. Where's your jacket at?
Hold on. Stand up, baby.
Here.
Yeah, thank you.
Go, just take
Scared the
that.
bejeebies out of me, dude.
Just wrap them up, keep them warm.
Let me hug you.
I just got woke up and
What's your name? You got ID?
baby, calm down. That's the right number. Yes, sir.
Where's Amanda Burton?
Is that who y'all looking for?
The room's registered to Mandy Burton.
No idea.
I thought that was 226. I don't know.
26.
I think so. With a blonde hair.
Yes, there's 226.
What you looking to do? Yeah, it's calm down,
They
baby.
got this room rented under their name too. Yes.
They
No,
must
no,
have
this
messed
ain't
up
even my
down
room.
there.
I just got
Let's go
woke up
talk
and
to
probably
her.
she's
That's
fine. The little girl was crying. That's that bitch.
Yeah, she's in 226.
Is that the...
She's got this room rented.
Baby, breathe. Calm down. You're okay. They're gonna
Take
do
his
the right
handcuffs off,
thing.
move to 226.
They're gonna do the right thing.
Where does key come?
Baby,
This key?
baby.
What's that?
It's good enough that you're
Yeah,
down.
give me the key. Stand up.
Baby, they're gonna do the right thing. Quit. He's taking care of it. Chill out.
Don't touch.
Yes, sir.
Y'all are in the wrong room under the wrong name.
Yes, sir.
My room's downstairs.
I'm downstairs.
You're gonna sit down right there, right now.
Yes, sir. Baby, calm down. Sit.
Sit down.
He's doing the right thing. Sit. Sit.
not in trouble. I just don't need you.
Yes, sir.
Put
He
your
don't want
phone
you
away
accidentally
from you.
hit, shot, nothing.
Go.
Just quit.
Don't touch.
Yes, sir.
226.
Baby, you okay? Let him do his thing.
The bail bondsmen go to room 229, which was being rented by a woman named Andrea with her children, and kick in the door. Motel guests, Lef Cooper and Brad Clark, who were staying in a room downstairs, were also in the room at the time, and the bondsmen order them to the ground and place Mr. Clark in handcuffs. Now, because the bondsmen had no legal relationship with the occupants of room 229, they were acting as private citizens in this encounter, and therefore they had no legal authority to enter the room without permission or conduct an arrest on any of the occupants. Accordingly, a court could find that the bondsmen committed multiple crimes under Arkansas law during their invasion of room 229. First, at a minimum, entering room 229 without Andrea's consent or a lawful justification likely constituted criminal trespass in violation of Section 5-39-203 of the Arkansas Code, which states that, quote, a person commits criminal trespass if he or she purposely enters or remains unlawfully in the premises owned or leased by another person. Likewise, a court could find that the bondsman's actions constituted residential burglary in violation of Section 5-39-201 of the Arkansas Code, which provides that, quote, a person commits residential burglary if he or she enters or remains unlawfully in a residential occupiable structure of another person with the purpose of committing in the residential occupiable structure any offense punishable by imprisonment. According to Section 5-39-101 of the Arkansas Code, the definition of a quote-unquote residential occupiable structure includes individual units of any building, now quoting, that is customarily used for overnight accommodation of a person, which would include a motel room, and they arguably entered with the intent to arrest the innocent individuals inside, which, as we will discuss momentarily, likely constituted another offense. Therefore, a court could potentially conclude that the illegal entry rose to the level of burglary. Additional crimes that the bondsman may have committed include false imprisonment in violation of Section 5-11-104 of the Arkansas Code, aggravated assault in violation of Section 5-13-204 of the Code, and so-called terroristic threatening in violation of Section 5-13-301. Now, while the bondsmen could certainly attempt to defend themselves by arguing that they believe they were entering this Perkins room, the hotel employee's statement suggests that they knew, or at the very least, should have known that they had the wrong room. And a court would likely find that there was at least probable cause to make an arrest for at least one criminal offense.
Yo, come in.
Golly, man. Come on, guys.
Maintenance! It's moved.
That room was rented under their people's names, but it wasn't under their people.
On the ground! On the ground!
That's him.
Hands behind your back. What's your name? David Turner. Where's Amanda? On the ground! Hurry! Hurry! Hurry!
Stop.
Hurry! To the side. Knees to your chest.
That's him.
Knees to your chest. Wash your hands. Touch you up.
Right there. Yep. Where's the gun?
On your knees.
You're known to have a gun every
All the way
fucking
down.
time, so.
Hands behind your back. Palms together like you're praying. These are hinged cuffs, and the more you move, the tighter they get. Me and you're fixing to stand up. Here we go. Pull your knees up, all the way. What's this?
Look.
You got anything you don't need to go into the jail with? You got anything, you're going to be charged with felony. Are these ones you're familiar with, boss? Pick that up and put it back. Stand right here.
Search for a gun.
Oh, sorry. I don't want to tear up the shit. Y'all want to look, make sure there's nothing that needs to be here? Because you know he's fixing to throw it all in the dumpster.
Especially the gun. That's something I was worried about. He's not
Yeah, you're going to jail. And you got warrants. He's got felony warrants. You got no. Yeah. Until you got caught with him.
Yeah.
He's been there for a while.
Damn, he's got like shields everywhere, dude.
You sure it's not a flashlight?
It's not mine.
That's mine.
I was excited. I was like, look at that. Why they got a nice flashlight?
Go ahead. Last name Bradley. First initial name for Matthew. Date of birth 3/17 of 85.
He had that gun. He'd have it handy.
Yeah.
He'd have it under a pillow or something. I checked those. I checked these. Only thing I found was one of the
What is
torches.
all this right here, bro?
Well, that's
I know, but I'm looking at this like,
Ain't
what
no
was
telling.
that?
All right, well.
After the bondsmen arrest Mr. Turney and Ms. Perkins and remove them from the room, the officers search the drawers and bags in their hotel room. Now, as we've discussed before here on ATA, law enforcement officers do have some authority to conduct a limited search incident to a lawful arrest. However, the Supreme Court established in the 1969 case of Chamel versus California that the scope of this search must be limited to the area within the arrest's so-called immediate control. Meaning, now quoting from that case, the area from within which he might gain possession of a weapon or destructible evidence. In the Chimmel case, officers lawfully arrested an individual in his home pursuant to a valid arrest warrant. They then searched his entire home over his objections, directing his wife to open drawers and move the contents from side to side, despite the fact that no search warrant had been issued. The Supreme Court determined that the search violated the Fourth Amendment's prohibition on unreasonable searches and seizures, holding that searching any room other than that in which an arrest occurs, or searching through drawers or other closed or concealed areas in the room of arrest requires a search warrant or an exception to the warrant requirement. In reaching this conclusion, the court reasoned that, quote, "We can see no reason why simply because some interference with an individual's privacy and freedom of movement has lawfully taken place, further intrusion should automatically be allowed despite the absence of a warrant that the Fourth Amendment would otherwise require." Now, although the Camille case discussed an arrest in a private home rather than a motel room, the Supreme Court held in the 1964 case of Stoner versus California that, quote, "No less than a tenant of a house, or the occupant of a room in a boarding house, a guest in a hotel room is entitled to constitutional protection against unreasonable searches and seizures. Therefore, it is highly likely that a court would conclude that the officer's warrantless search of Mr. Turns and M. Perkins' bags was a violation of the Fourth Amendment, as it could not be justified as a search incident to arrest, since the bags and drawers were well beyond the arrest's so-called reaching distance, and there were no exigent circumstances requiring an immediate search of the bags and drawers. If the officers wanted to search the bags for evidence, well then the lawful course of action would have been to secure the room and then obtain a search warrant from a judge.
We're taking them both to Pulaski County.
Awesome.
Have a good ride.
Look, two less pieces of y'all got.
No, man, we appreciate it.
Y'all want to charge her with hindering apprehension?
Nah.
Just let her sit on her own prostitution warrants?
Yeah. I'll keep her for a while at least with that.
Oh, she got no bond holds, so she ain't getting out.
What's his warrants for?
Aggravated assault, terroristic threatening, possession, simultaneous possession.
Awesome.
So, I mean, shut it. He's always had a gun.
That's the only thing I was worried about. That way you guys ain't got to deal with that.
Yeah, we got enough of that to deal with around here anyway.
Look at that. We're done in 30 minutes.
34 on your turn.
After his arrest, Mr. Attorney entered a negotiated guilty plea to felony charges of possession of a controlled substance and unlawful possession of a firearm, and was sentenced to 5 years of probation with 115 days in jail credit. Ms. Perkins repeatedly missed scheduled court dates for her charges, resulting in the addition of several additional charges for failure to appear. And on January 4th, 2025, she was charged with theft for an unrelated incident, and then failed to appear for the scheduled court date for that offense. As of the date of writing this episode, a failure to appear warrant has been issued for her arrest, and all of the criminal charges against her are still pending. Ms. Cooper and Mr. Clark stated in an interview with the Random Patriot, who also covered this encounter, that they filed a complaint with the prosecuting attorney's office in Little Rock and hoped to pursue criminal charges. They also indicated that they intend to file a civil lawsuit against both city bail bonds and the city of Jacksonville. Mr. Clark additionally claimed that city bail bonds offered to pay for their hotel room for a week in an attempt to rectify the situation, and that he refused the offer. If you're interested in listening to the entire interview, I have included a link to the Random Patriot's coverage of this incident in the description down below. Overall, the bondsmen get an F for utterly failing to ensure that the information they were working with was accurate, breaking into the wrong hotel room, and terrorizing an innocent family as a result, and for maintaining a hostile and confrontational demeanor throughout the interaction. The conduct of the city bail bonds agents in this interaction was not only indefensible, but arguably criminal. After being explicitly informed by the hotel employee that the individuals they were pursuing were located in room 226, the bondsman forcibly entered room 229, which was occupied by unrelated guests, including a mother and her children. They proceeded to handcuff one of the occupants and order others to the ground, all without any legal authority to be in the room or to detain its occupants. Because the individuals in room 229 were not bonded by city bail bonds, the agents had no lawful justification for entering the room or attempting any form of arrest. In doing so, the bondsman likely committed a slew of criminal offenses under Arkansas law, including criminal trespass, residential burglary, false imprisonment, aggravated assault, and potentially even terroristic threatening. Although they could claim that they mistakenly believed that they were at the correct room, the evidence overwhelmingly suggests that they either ignored or failed to properly interpret clear information from the hotel staff. Their actions were not merely negligent. They were reckless, dangerous, and egregiously unlawful. Furthermore, after falsely arresting an innocent father and ruining a child's birthday party, the bondsman offered to pay for the hotel room for another week, as if that was appropriate compensation for what that family was subjected to. This interaction highlights the legal gray areas that often surround interactions involving bondsmen, where private actors wield quasi-law enforcement powers with minimal oversight, often blurring the line between lawful authority and outright vigilantism. The Jacksonville officers also get an F for failing to intervene or take action during or after what was clearly an unlawful entry by the bondsman, for demonstrating fundamental misunderstandings regarding the authority of bondsmen and for likely committing an illegal search on the hotel room after the arrests were made. Now, although the Jacksonville officers did not personally participate in kicking down the wrong door, their failure to intervene or halt the illegal actions of the bondsmen makes them complicit in a deeply troubling sequence of events. Law enforcement was present on the scene as a safeguard, but instead of protecting the rights of the innocent motel guests, they stood by while private actors invaded a hotel room, detained uninvolved individuals, and violated the sanctity of a private residence. What's particularly troubling is that after the correct individuals were taken into custody, the officers proceeded to search bags and drawers in the hotel room without a warrant, an act that flies in the face of well-established Supreme Court precedent. These were not ambiguous circumstances. The officers' conduct represented a clear departure from constitutional norms, and their passive role during the unlawful entry into room 229 further eroded public confidence in their judgment. The officers failed to uphold the most basic protections of the Fourth Amendment and stood idly by while a flagrant abuse of power unfolded. The sheer lack of awareness and ignorance of the law surrounding this encounter is deeply alarming, especially coming from sworn officers who are entrusted with upholding those very laws. Their inaction in the face of blatant constitutional violations and their own participation in an unlawful search reflect not just poor judgment, but a fundamental failure in training accountability or both. In a situation where restraint, oversight, and legal clarity were desperately needed, the officers instead became enablers of lawlessness. Now, as for the occupants of room 229, I cannot rightfully issue a grade to a family who were purely the victims of both private and public sector harassment and constitutional violations. Despite being confronted by armed individuals who forcibly entered their room without legal justification, the occupants complied with the commands issued to them and did not escalate the situation. According to subsequent interviews, Mr. Clark and Miss Cooper pursued lawful avenues of recourse by filing a complaint with the prosecuting attorney's office and considering civil litigation against both city bail bonds and the Jacksonville Police Department. Their response to this egregious violation of their rights was measured lawful and entirely justified. I commend Miss Cooper and Mr. Clark for remaining calm in an extremely stressful situation and for following up this encounter with the proper legal action. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below.